From the Library of Congress in Washington, D.C.
Good morning. I'm TJ Halstead, the Deputy Director of the Congressional Research Service, and it is my pleasure to welcome all of you, our distinguished panelists, guests, and friends of the Library of Congress, and to thank you as well for joining us today as we celebrate Human Rights Day. Human Rights Day is officially observed every year on December 10th to commemorate the adoption of the Universal Declaration of Human Rights by the General Assembly of the United Nations in Paris on December 10th of 1948. The Declaration was designed to provide a global framework for human rights following World War II and the end of the colonial era. The Declaration can be accurately characterized as the first truly global enunciation of human rights and is considered the most translated document in modern history. It's available in more than 360 languages, and new translations are added on a regular basis. Given the status of the document, its history, and its impact on legal systems around the world, I think it is very fitting that my colleagues at the Law Library of Congress, the world's largest law library and a leading research center for foreign, comparative, and international law, are hosting today's event. Today's program, The Impact of the Miranda Warning on Human Rights in Eastern Europe, will address how American laws have affected human rights developments in Romania and the former Soviet Union. Before I introduce my friend and colleague, Mr. Peter Rudik, who will serve as today's moderator, I kindly ask that you switch your mobile devices to silent mode, and please note that this program is being videotaped and will be presented later as a webcast on the library's website. At this time, I welcome Peter Rudik, head of the Law Library's Global Legal Research Directorate, to the stage, who will share more details about today's program and introduce our distinguished panelists. Peter, thank you very much.
Thank you, TJ. As TJ mentioned, today we are celebrating the adoption of the Universal Declaration of Human Rights in 1948, which provides a global framework for human rights. But today's event also marks the 50th anniversary of the 1966 Supreme Court decision Miranda versus Arizona, which the library has been commemorating throughout this year. This landmark Supreme Court ruling requires that criminal suspects will be informed of their constitutional rights at the time of their arrest and before interrogation. The Law Library began commemorating the anniversary of Miranda for Law Day, when we hosted American Bar Association President Paulette Brown, who discussed with us procedural protections afforded by the United States Constitution and safeguards by the courts, and how they are essential to our liberties. Then in July, we hosted a law and film event, which highlighted how the reading of the Miranda warning has evolved over the last 50 years. We view one's right to be informed about his or her right as a human right. And that is why today we conclude our commemoration of Miranda by examining how this ruling and American legislation in general has served as an inspiring example for those who fight injustice in other countries. Also, it is not a coincidence that today is the Anti-Corruption Day, which is celebrated on this day since 2003, when the UN Convention Against Corruption was adopted. All these issues are interconnected, and all these issues will be discussed today during our discussion. And that's why I'm honored to present our distinguished speakers to you, who will discuss the Miranda warning and human rights in other countries. Today we are joined by Kyle Parker, Senior Professional Staff Member of the United States House of Representatives Foreign Affairs Committee, Dr. William Pomerantz, Deputy Director of the Kennan Institute for the Advanced Russian Studies of the Woodrow Wilson Center, Honorable Monica Macovei, Member of the European Parliament and former Minister of Justice of Romania. She just came from Brussels to participate in this panel, and we are very thankful to you for that. And the Russian journalist, historian, and the prolific author, Natella Boltinskaya. Of course, you are waiting to listen from our speakers, not from me, so I'm really honored to present them for you. We have practitioners, scholars, academics, politicians, and we will have the opportunity to hear from each of them individually and then to have a discussion. At this time, please join me in welcoming Kyle Parker to the stage.
Thank you, Peter. It's an honor to participate in today's discussion here at the Library of Congress. My first job in Washington was actually helping to start the Library of Congress's Open World program back in 1999, a program that was conceived by Dr. Jim Billington and academician Likhachov in Russia. It began as a high-level exchange between Russia's Federal Assembly and the United States Congress. And now, as a congressional staffer, I regularly rely on the expertise of the Congressional Research Service, as well as the attorneys at the Law Library, to do my job. And frankly, one of the best perks I feel of being a congressional staffer is the ability to go online late at night at my house and order a book from the largest collection in the world and have it sitting on my desk the next day. So it's good to be here. As you mentioned, Peter, our conversation is especially timely in addition to marking 50 years since Miranda versus Arizona and Human Rights Day. Yesterday marked 25 years since the signing of the Belavesia Accords, which dissolved the Soviet Union. So it's as good a time as any to take stock of where we've been and where we may be headed as a new administration takes power here in Washington. Now, under the new rules of the House of Representatives, all legislation we introduce must be accompanied by a statement naming the relevant parts of the U.S. Constitution, giving Congress the authority to legislate on the subject of the bill to be introduced. So let me start off with what I consider to be something like a constitutional authority statement for U.S. advocacy on human rights in Europe. It comes from the Organization for Security and Cooperation in Europe's 1991 Moscow document and states that, quote, "The participating states emphasize that issues relating to human rights, fundamental freedoms, democracy, and the rule of law are of international concern, as respect for these rights and freedoms constitutes one of the foundations of the international order. They categorically and irrevocably declare that the commitments undertaken in the field of the human dimension of the CSCE are matters of direct and legitimate concern to all participating states and do not belong exclusively to the internal affairs of the state concerned." End quote. This unambiguous declaration was reaffirmed at the most recent OSCE summit in 2010, and the commitments referenced happen to be the richest body of human rights commitments that bind all of the OSCE's 57 participating states, which of course includes all of Europe, the countries of the former Soviet Union, as well as the United States. Obviously, there are many other reasons for the United States to care about rights that are universal and inalienable, but this is a pretty good one to cite to those who would dismiss our concerns as meddling in others' internal affairs. In fact, during my time at the U.S. Helsinki Commission, I used this declaration as my email signature. Now, I was asked to give the American perspective and will do so today as a practitioner of human rights policy in Congress. And as far as human rights in general and human rights in Europe, Congress leads the United States government in advocating for and legislating on fundamental freedoms. As the branch of government closest to American civil society, which cares a great deal about human rights, Congress often sees merit in ideas and causes that bureaucrats and experts may find inadvisable, unrealistic, or even impossible. But it's precisely this institutional tension that produced monumental human rights legislation addressing abuses in Eastern Europe since Miranda. These are the Jackson-Vanik Amendment of 1974, the creation of the U.S. Helsinki Commission in 1976, and the Magnitsky Act of 2012, and most recently, the Global Magnitsky Act, which is on its way to the President's desk for signature as we speak here this morning. I spent nearly a decade covering human rights in Russia at the U.S. Helsinki Commission, which in the 1970s and 80s was the lead U.S. agency for advocating for Soviet dissidents, Jewish refuseniks, and the captive nations. But during my time on the Commission, we focused on corruption. instead of communism. And while fighting corruption and promoting human rights is not the same thing, there's enough overlap to at least allow the casual use of one term to also include the other. In early 2009, I reluctantly accepted a meeting that would dramatically change how I viewed human rights advocacy, set a new precedent for how the United States responded to human rights violations in Russia, and now offers a powerful new mechanism to address human rights violations around the world, and one that happens to be uniquely suited for this current era of shrinking budgets and extreme transparency. This meeting was with Bill Browder, who previously managed the best-performing hedge fund in the world and was for a time the largest foreign portfolio investor in Russia. I didn't know him personally, but remembered him as being a champion of Vladimir Putin's early economic reforms, which made Browder's expulsion from Russia in 2005 all the more notable and perplexing. Bill came to tell the story of his tax lawyer, Sergei Magnitsky, who was in pretrial detention in Moscow for having exposed the largest tax fraud in Russian history and was being subjected to increasingly torturous conditions. Sergei's story was remarkable in that it was a departure from the usual tale of wealthy Russian businessmen who had fallen out of favor with the Kremlin and then were facing something that might charitably be called selective justice. But Sergei was a young, middle-class Muscovite who was not involved in politics, whose client lost no money, and was seeking only to understand what we now know, thanks to Magnitsky's heroic efforts, to be an elaborate scheme involving senior officials, organized crime, and the offshore zone to steal at least $500 million from the Russian treasury and launder it abroad. This fateful meeting with Bill was the beginning of efforts outside of Russia to save Sergei and later to honor his commitment to the truth. Now, it's easy to get jaded on the human rights beat in Russia, and work at the Helsinki Commission in the Putin era was frustrating, low profile, and with few visible successes. The North Caucasus simmered with low-intensity conflict, creating a long list of victims of forced disappearances and torture. Russia's free media and civil society were under increasing pressure, and the United States was making a concerted effort to improve relations despite these obstacles. I speak in the past tense because I no longer work at the Commission, but as we all know, the Putin era continues and the situation has worsened. At the Commission, I saw my job as scanning the horizon for cases where our attention might be able to make a difference, and for cases that would be of particular interest to our bipartisan congressional leadership. Not always an easy thing to do. Whenever I learned of a case that met these criteria, our usual approach was to try and get a senior U.S. official, preferably the Secretary of State or even the President, to raise the case with their Russian counterparts. Frequently, we would only learn if the case was raised in the broadest possible terms, and usually from a response from some lower-ranking official we didn't even write to, thanking us for our concerns and assuring us that they shared the same concerns. Basically, the sort of mealy-mouthed letter that makes you even angrier than had you been completely ignored. And the Russian government never paid any attention to these interventions, nor did the press. And then another journalist or human rights activist would be killed, with little hope of ever finding those responsible. And we'd dash off yet another press release condemning the latest human rights outrage. It was all very unsatisfying, but it was what we did because we had to do something. In an attempt to be fair and spread our attention, I had a few active files on my desk, and if I had been focusing on one for a while, I'd try to focus on another. And somehow the sense that there were probably thousands of cases much worse than the ones we were aware of was strangely given as an excuse for not doing something on the cases we did know about. In the summer of 2009, human rights activist Natalia Estemirova's bullet-riddled body was found on a roadside in Ingushetia. She had visited our Washington offices not long before her death, and it felt entirely inappropriate to merely condemn her brutal murder. The time had come for action. But again, what could we do? At the Commission, Estemirova's murder would be the last death of an activist where our response would be limited to the same old ineffective tools of pleading for high-level U.S. attention and calling for investigations that are unworthy of the name. A few months later, on November 16, 2009, Sergei Magnitsky, whose plight we learned about earlier that year, was handcuffed to a bed in an isolation cell and beaten by prison guards until he died. His torture and ultimately murder was rigorously documented in his detailed and voluminous legal complaints and by the bureaucratic and authoritarian system that killed him. Sergei was a young, idealistic Moscovite who placed great hope in then-President Medvedev's promise to end what Medvedev himself had called legal nihilism, only to become its most emblematic victim. At the Commission, we began work immediately on assembling documentary evidence of his false arrest, illegal detention, torture, and murder, as well as on the massive tax fraud against the Russian people that he gave his life to expose. We also combed federal law for precedent on how we could address his case in the United States, given that a cover-up was gaining speed in Moscow. We found a Bush-era executive order called Proclamation 7750, giving the President authority to bar foreign persons engaged in corruption from entering the United States. Losing a visa seemed a ridiculously small strike at impunity, and we weren't even sure if any of those involved visited or had planned to visit our country. But in April 2010, Senator Cardin, who was the Senate chairman of the Helsinki Commission, and now the ranking member of the Senate Foreign Relations Committee, decided to send an open letter to Secretary Clinton, including a list of 60 Russian officials complicit in Sergei's false arrest, detention, torture, and death, as well as those involved in the crimes he exposed, and asked that she use this authority to publicly ban their entry. Given our previous experience of sending letters into a non-responsive void, we didn't expect much. But after releasing this letter late on a Sunday night, as Moscow was waking up on Monday, we awoke in Washington to fireworks in the Russian press, dramatic headlines in the Western press, and Secretary Clinton wanted to see the senator. If we engage our effectiveness by their reaction, this list was a direct hit. In fact, I think it was Newsweek that ran the headline, "Cardin drops bomb on Russia's corrupt elite." And Russia's leading anti-corruption activist, Alexei Navalny, posted the list on his website with a one-word headline, "Wow." The Spisak Magnitskого had become a rallying cry. We had finally discovered the Achilles heel of corrupt officials in Russia and around the world, their exposure to the West. Having trashed the rule of law at home, they stash ill-gotten gains abroad in countries where in countries with due process that respect human rights. They also keep passports with multi-entry visas handy in case they fall out of favor and need to make a quick exit. Moreover, ours was an asymmetric response that couldn't easily be countered. The Kremlin tried banning U.S. officials and freezing their assets, and were met by jeers from their own citizens. They also tried banning U.S. officials they viewed as having violated human rights, only to be drawn further into a public conversation on the importance of protecting those rights. This new technology for keeping human rights on the agenda was also a fairer response. It shamed individual violators without saying anything about their country as a whole or blocking any business deals or trade. Further, it was an approach that cost nothing and was easily replicable in other countries, quietly or with public debate. In fact, this week, Estonia became the first European country to pass a Magnitsky-styled law, and similar proposals are now pending in the United Kingdom and Canada. In the coming months and years, we fought an uphill battle spanning 2 Congresses to take this idea that had the proverbial snowball's chance into a new section of the United States Code. Throughout the campaign, our greatest support came from Russia's besieged civil society and from the international human rights community, while our greatest resistance came from the administration, the Kremlin, and the trade lobby, in that order. In fact, it was the administration's proxy blocking in Congress that led to the Magnitsky Act being tied to Russia's Jackson-Vanik termination, and it was the administration's desire to spare Russia that led them to propose that Congress make the act explicitly global. They later reversed course and joined the House leadership in insisting that it be limited to Russia. The original Magnitsky Act also set the stage for our response to Putin's unprovoked and illegal war in Ukraine, with many of the early targets of the Magnitsky legislation being added to Treasury's specially designated nationals list by executive order. Should those sanctions ever be removed prematurely, here or in Europe, I suspect that the Magnitsky Act will stand as the most prominent rebuke to the violent kleptocracy currently ruling Russia and menacing the entire region. The new Global Magnitsky Act builds on the successes of the original act and may prove a valuable tool for the new administration to target human rights abusers in China, in Iran, in Cuba, or anywhere in the world. I hope they implement it vigorously, and I'm confident that the human rights community, as well as Congress, will be encouraging them to do just that. Thank you.
Thank you, Kyle. Dr. Pomerantz, please.
Well, thank you very much, Peter. It is always a pleasure to be at the Library of Congress and to walk by the Law Library of Congress. A brief story. I did a PhD for 5 years, but I always like to say I have 5 days I remember the most. And one of those 5 days took place at the Law Library, and this may date myself, where I was given a stack pass and allowed to go into the depths of the Library of Congress, press some buttons that I couldn't quite understand, but nevertheless books began to appear. And all of a sudden there in front of me was the largest collection on the pre-revolutionary advocatura, the legal profession in Tsarist Russia. And I smiled because my PhD had gotten a huge lift that morning. And it was all thanks to the law library. And I proceeded to spend a good 3 months digging through what was available. And it was just a tremendous, tremendous opportunity. I'm going to follow on Kyle, but take a little different approach to the discussion of Miranda, because as was mentioned at the beginning, our goal is not only to look domestically, but also internationally, and looking at how U.S. law impacts foreign law and influences human rights. I'll focus primarily on Russia, but I'm also going to talk about other post-Soviet countries as well. And in the spirit of the Miranda warning, I'm actually going to delve into criminal procedure within the Russian criminal justice system, but then expand to talk about broader issues about how the United States promotes legal reform abroad, and at the very end, a general discussion about the direction of Russia's legal trajectory. Now, to do so, I want to issue one caveat at the beginning. I just finished reading a fascinating and in many ways upsetting book called Just Mercy by the lawyer Brian Stevenson, who details the problems of wrongly condemned people in the U.S. justice system. Suffice to say, when you have a chance to read about the underbelly of the U.S. criminal justice system, it has its fair share of problems and unpleasantness as well. So I want to emphasize that the Miranda warning is always the beginning of the process. It does not eliminate necessarily long-standing biases within a legal system that can lead to unjust verdicts. And that is true of all legal systems and not just Russia. But as I mentioned, I'm going to begin with criminal procedure, and I'm going to start with the passage of the Russian Criminal Procedure Code in 2001. Now, I was doing the math and I realized that was just 15 years ago, but it really harkens to another era in Russian history, because the Criminal Procedure Code was signed by one Vladimir Putin. And at the time, it was perceived in many ways as a very important liberal reform, transforming the Russian criminal process and holding out the promise of reforming the corrupt Soviet legal system that was still in place inside Russia. Now, the 2001 Criminal Procedure Code does possess a Miranda-style warning, stating that when a suspect is detained or is in custody, that person has the right to know of what he or she is suspected of. He or she has the right to obtain documents related to the instigation of the criminal case. And that person has a right to avail themselves onto the advice of legal counsel. Yet 15 years afterwards, few would argue that the Russian criminal justice system has lived up to that warning or indeed to Western standards. And the question is, why is this so? Or to ask the question another way, Why has a Miranda-style warning become superfluous within the Russian legal system? And the answer can be found in a fascinating statistic inside Russia, and that is the conviction rate of Russian criminals who go to trial. And that statistic is 99%. Similar percentages exist in other post-Soviet republics as well. And the question when you look at that is, how can that be? Why is it that 99% of all people who go before face inside the criminal justice system end up being convicted? Now, on one hand, you might think that maybe Russia has some outstanding criminal investigators who are diligent and impartial and always are able to get their man, but that really isn't the case. You also might think that it's because of rampant corruption. And in certain economic cases, there are plenty of examples of corruption, but the average Russian criminal defendant is male, poor, uneducated, and without any resources necessarily to bribe a judge. So it's not really corruption as well that explains the 99% conviction rate. The major problem, as I would put forward, and as Russian scholars have themselves argued, is that the incentives are all wrong. What do I mean by that? Because when you look at how certain legal institutions and practitioners are evaluated, they're evaluated based on convictions and acquittal rates. So for example, if I'm a prosecutor in Russia and I want to get on in the system, I will be judged by how many acquittals have resulted in my prosecutions. So in other words, acquittals work against me if I want to advance within the Russian criminal bureaucracy. Similarly, if I'm a judge, I will be evaluated by the percentage of cases that are overturned. Again, most of the cases that are overturned in the Russian criminal justice system are acquittals. So again, if I'm a part of the Russian legal bureaucracy, I have certain incentives not to break the system. And that is really not to somehow challenge this fact that Russia has a 99% conviction rate. Now, Russia has adopted an adversarial system, at least at trial, where a defendant is represented by a lawyer and the state is represented by the prosecutor. But as I noted above, by the time one gets to trial, the decision essentially has been made. I once talked to a Russian defense attorney and asked him, well, what do you tell your client before you go to trial? And he informed me he tells them that they have a 1 in 100 chance of getting off. Again, you can imagine that, how that goes down with the client, but nevertheless, there are people who are still willing to fight within the system. But if you're somehow going to get the charges dropped against you, the crucial time to do it is in the investigation process. And during the investigation process, the Russian legal system primarily retains the inquisitorial system that has so long prevailed not only in the Soviet period, but even in the Tsarist period as well. And under an inquisitorial system, it is the investigator that controls the investigation and the course of inquiry. And in many cases, the advocate or the lawyer, the defense attorney, is appointed and paid by the state, and in order to keep this steady stream of appointments going, is unwilling to challenge the state. Now, the Criminal Procedure Code does allow defense attorneys to interview witnesses and submit evidence into the case file during the preliminary investigation, but that evidence is assumed to be biased in many cases because it is submitted by the defense attorney. Now, you may ask, where is the Russian judiciary in this process, which is the logical check on potential abuse by investigators and prosecutors. And not surprising, the judiciary is part of the problem, not the solution as well. In the US and in other legal systems, an appointment to the judiciary is really the final step in a career, whereas in Russia, one can become a judge at the tender age of 25. Now, the also important aspect of the Russian judiciary is that it is drawn mainly from the judicial bureaucracy, prosecutors, court secretaries, and so forth. It is not drawn from the defense attorneys, the people who have the most kind of practical experience. And that is for a variety of reasons, but it means that the judiciary is kind of overflowing with people of the system. and so the long-standing biases against the criminal defendant perpetuate themselves and limit the impact of any Miranda-style warning to defendants. And this leads to my second point, one that is well known but also deserves repeating, and that is promoting human rights and legal reform is not just about establishing new procedural guarantees of what is written in the law. It also requires the reform of institutions. And as we have learned that post-Soviet legal institutions have proven highly resistant to change. This is not just true of the judiciary, but also true of the prosecutor's office. And the legacy, the Soviet legacy that has affected prosecutors and the position of prosecutors in the post-Soviet space has best been seen recently in Ukraine and not in Russia. And the assumption is, again, that the prosecutor resembles an American prosecutor, or at least a prosecutor in the continental system, where their primary responsibility is to represent the state's interests in court. And the answer in the post-Soviet space is no. A Ukrainian prosecutor, like a Russian prosecutor, possesses far more administrative and supervisory responsibilities than his or her Western counterpart. And the institution of the head of the prosecutor's office is also tied to a political leader. It is no accident that the prosecutor's office has been known as the eyes of the state for almost 3 centuries in post-Soviet Russia, the Soviet Union, and in the imperial period. So when Ukraine began to reform in the aftermath of the Euromaidan revolution 2 years ago, it gradually became apparent that one of the main stumbling blocks was the prosecutor's office itself. The prosecutor's office stood at the nexus and in many ways successfully blocked 3 reform processes: anti-corruption, the division of powers, and the rule of law. And it was no accident that a very frustrated Vice President Joseph Biden felt necessary to call the president of Ukraine and demand that the head prosecutor be fired. Now, Poroshenko was very reluctant to do so, in part because his ability to control the head prosecutor, who reports directly to the president under the Ukrainian constitution, was one of the few sources of leverage that the president had within the Ukrainian political system. But even though Poroshenko was ultimately agreed to fire the head of the prosecutor's office, he was not in a position to fire 18,000 other prosecutors who were also tainted by the previous system, who are also part of the Soviet legacy. And that is the dilemma of the reform process that the United States tries to deal with, because the United States prides itself in evolutionary reform, but it's much more difficult to pursue this notion of evolutionary reform in a legal system that is still weighed down by Soviet legal institutions. Now, what is required in order to address this problem is political will. And we are still waiting to see to what extent the political will exists in Ukraine to transform its legal system. Such political will is noticeably lacking, of course, in the Russian Federation. That is not to say that Russians have necessarily abandoned their legal system. One of the fascinating things about Russian law, if you follow it, is the increasing number of civil cases that take place in Russia, and the willingness of average Russian citizens to turn to the courts to address everyday complaints, a leaky pipe, common spaces, all these types of issues. And so the fact that so many Russians are willing to turn to the courts for everyday civil suits is really one of the underappreciated aspects of legal reform and the nature of the Russian legal system itself. People don't go through the difficulties of pursuing legal cases unless they believe they have some chance of resolution at a certain level. Nevertheless, Putin's return to the presidency in 2012 has been accompanied by a dramatic deterioration in the human rights situation in Russia, and Kyle has highlighted some of those in terms of the legislation that has been passed, the Foreign Agents Law, the law restricting the right to protest, freedom of assembly, anti-gay legislation, anti-blasphemy legislation, and so forth. We've also seen the politicization of the legal process since Putin returned to office. And again, there is a growing number of cases that can be cited there. And finally, in the aftermath of Crimea, we now have the human rights disaster in Crimea, as well as in eastern Ukraine, where we really have seen kind of the deterioration of any sort of legal decisions. All those issues impact human rights in Russia today. All of them need to be followed. All of them need to be included in any assessment of the rule of law and Russia's legal trajectory. But as I draw to the end of my comments, I'm going to focus on another alarming development in Russia's legal evolution over the past year, and that has been a decision by the Russian legislature to pass a law that allows the Russian Constitutional Court to overturn decisions by the European Court of Human Rights. Now, one cannot underestimate how important Russia's decision to sign the European Convention for Human Rights and become a part of the European Court has been. It has allowed Russians to appeal human rights infractions to Strasbourg. It has allowed, Strasbourg in turn has imposed significant fines on the Russian government that it has to pay in order to address human rights violations. And finally, Russian courts have referred to the convention and to individual European court rulings when making their decision. So if you want to look at the evolution of Russian law and how foreign law has been able to penetrate Russian law, one of the best examples to date so far has been the European Convention and European Court decisions. Now, as I mentioned, in 2015, Russia established a mechanism whereby the Russian Constitutional Court can overturn European Court decisions that violate the Russian Constitution. Now, admittedly, European countries have been very good at finding ways to avoid implementing European Court decisions themselves, but they have never gone so far as to establish a specific legal procedure that allows a domestic court to overturn a European Court decision. The Russian Constitutional Court has already done so in one case, in a prisoners' voting rights case, and it looks like it's going to do so again in an upcoming Yukos decision. So therefore, as someone who monitors human rights in Russia, I will be paying strict attention to how the relationship between Russia and the European Court of Human Rights evolves. It has been severely tested in the past, but Russia has never been so bold as to leave the European Convention or to walk away from Europe, but it will come under increased scrutiny and pressure going forward. I should add that the Constitutional Court in Russia will also be coming under increased scrutiny. One of the first reforms that Vladimir Putin did when he came to power was abolish one of the high courts in Russia, the higher commercial courts, and rolled it under the Supreme Court. And I think there's a genuine fear that Putin will take a similar approach to the Constitutional Court and roll it under the Supreme Court as well. So in conclusion, I think we are, as again Kyle mentioned, and I'm sure everyone is aware, we are really entering a new period of U.S.-Russian relations, and it remains unclear in many ways what role human rights will play in U.S.-Russian relations going forward. Part of the challenge will be to focus and to highlight those human rights abuses inside Russia and around the world as well. The other part of the challenge, however, is to live up to our own ideals, which are in so many ways symbolized by the procedural protections and guarantees articulated in the Miranda decision.
Thank you, William. Ms. McAvey, please.
Do you mind if I speak here?
Yes, please.
I'm used to speak standing. Are they working? Yes. I used to speak standing. Hello, everyone, and I'm happy to have made such a long travel to be here with you today. And I also am happy that about this coincidence that we celebrate Anti-Corruption Day, International Anti-Corruption Day, and International Human Rights Day. One is today, one is tomorrow. Today is Anti-Corruption Day, tomorrow is Human Rights Day. And maybe that's not a coincidence. We can't talk about civil rights in a corrupt country, in a country where the state is captured and captive to corruption. Now, listening to my the previous speakers, I see some common background. I also served as a member and then as a president of the Romanian Helsinki Committee. I know it's different than your Helsinki Commission in the Congress, but it deals with human rights. And I took to the European Court of Human Rights, to which you last referred. As a civil rights lawyer, I took about 20 cases of Romanians whose rights have been violated by the state, and I won them all. And that was one of the happiest periods in my life to write these applications. Most cases refer to people beaten up by the police or even killed after being beaten up by the police. Also property cases and journalists being imprisoned for criticizing political figures. Imagine at the beginning of '90, Romania ratified the European Convention of Human Rights in '94. Politicians didn't didn't accept that they are criticized by journalists. So we had criminal offenses to take them to prison. They were called offense against authority. So a politician was the authority itself of the state. So if you criticize the politician, insult the politician, then you insult the authority of the country and you go to prison. Okay, this time are gone, but this European Convention of Human Rights helped a lot, and all these cases helped a lot to change the country, and I assume not only in Romania, in all these countries in Central Eastern Europe. On Miranda rights, yes, it also helped. I'm supposed to speak about this in Central Eastern Europe and in the Balkans, but I will just have one significant difference. We informed the accused people of their rights, including the right to keep silent, including the right to have a lawyer, including the right that anything you can say can turn against you. But this happens not the moment you are taken from the street, if you are taken from the street, but the moment when you are interrogated as a suspect. So, because we consider a person to be arrested after he's kept a number of hours during interrogations, or it could be 1 hour and then it's an arrest warrant. But not when you are taken from the street, from the barber shop, from your house, and so on. So we apply it, but not in the same moment as you. In the European Union, we have a Human Rights Charter, and also we have minimal standards for the defendants, and informing the defendants or the accused people about their rights, it's one of these minimum standards. And also referring to foreigners, we have to do it in their language they understand. Now, I said at the beginning that it's not a coincidence that Anti-Corruption Day and Civil Rights Day are so close, like in one, because in a corrupt society we cannot speak and we cannot argue that there are civil rights respected. Corruption creates a double reality, like those mirrors in which kids look and the reality is deformed and their bodies are deformed. I don't know exact word in English, but that's what corruption creates, because if you have a judgment of a judge based on corruption, then you create a parallel reality, another reality, which is determined by corruption. If you have a government decision based on corruption, then again it's another reality. If you have a building permit based on corruption, then it's another reality. All of these are illegal reality, but they're realities because they happened in reality. That's what I'm saying, that it's a parallel reality determined by corruption. And then we can't speak about civil rights. In the post-communist countries, we all have high-level political corruption, and I'd like to refer to this. And looking back, looking back, I'm sorry, I have a flu, but I think you can understand me. I said in the former communist countries, we all have high-level political corruption. Thank you. But it's very cold. You use a lot of ice. A tea would be better. It's fine. Think that in 1990 we had to move from a state which was dominant by the government, the communist government, to democracy, and from the state economy to the market economy. You want some water with ice?
I have some as well. It's okay.
Now, this means that that a lot of money, large amounts of money, had to move from state hands to private hands. Think of privatizations, yes? We all said the state is a bad administrator, we need to privatize. So huge values move to the private hands. Then we need to redo the infrastructure, again, by whom? By private companies, which were just forming. And again, large amounts of money moved to the private companies, to the private hands. Now, these were opportunities which were taken right away by the people who didn't think of freedom, of democracy, but they thought how to make money in these great times. And we did privatizations and all this public procurement without even, at the beginning, without even having laws. It was just a law for this case, and then another law for another case of privatization. Or the laws were in continuous changing. So in a way, it was inevitable to reach this point. Also, the judiciary was afraid, was poor. The law enforcement the police officer were even afraid to go on the streets for not being, I can't say killed, but not being molested by the people. And also the judiciary was not trained. No one knew at that time what was money laundering, for instance, or many other crimes which exist today. Also, the accountability of politicians in front of the population was very low because people didn't know what accountability was. Yes, they were used that what politicians do and say, that's it. It took time, all this took time, but during this great time, we got these oligarchs, we call them the same like in Russia, which means you get political power, then you also are a businessman, and then you realize that you need the media. And so they bought the media as well, and now we have, not only in Romania, in all countries in the region, we have oligarchs owning the media. And they all declare their TVs like the most independent news post. They don't have at least the honesty to say, okay, this TV is broadcasting for this party, for at least the people to know to what they look. Now, all television, all radios are the most independent news post. So that's a problem we have. I'll come back to, and I'll give you some examples, fighting corruption in these countries. Now, when you say we fight corruption, political corruption, it means you have corrupt politicians. So fighting political corruption could be a contradiction in terms, because if you have corrupt politicians, you go to these corrupt politicians and ask them to adopt legislation which would go against themselves, yes? Which would take them to prison, which would confiscate their assets, and so on. Now, I succeeded to do this in Romania when I was a Minister of Justice 2 years before Romania's accession to the EU, only because it was pre-accession. Otherwise, I wouldn't have done it. And I was fired after the accession. They said enough anti-corruption. So politicians, if they have to choose between the good of the country, the public good, and their own freedom, assets, and their well-being, no doubt that they will choose in that area of the world, they will choose their personal interest and freedom, and not the big good, and not the good of the country. And they don't even care what, what ambassadors say, what the EU says, what NATO says. No, they care about themselves, to not go to prison or to keep their assets outside any confiscation. And I'll give you an example. So I became, I came from the civil society. I just received a telephone from the then elected president, and I became a minister without being part of any political party. That's possible in Romania. And the argument was that if we really do the fight against political corruption, then the Minister of Justice should not be a politician. Okay, this convinced me. Sorry? So here I was with the political government. I was supported by one of the parties. There were 4 parties in a coalition, but I had my objective and my way. I remember I set up the Anti-Corruption Prosecutor's Office, and I said, you investigate anyone based on evidence. It doesn't matter if the person is in power or in the opposition, which never happened before. And it happened that the first person to be investigated was the Vice Prime Minister of the government I was in. So the news appeared in the newspapers, and then we had the government session, and the Prime Minister said, Monica, I thought we go after the opposition. So I said, we don't go after anyone. We are not hunting here. It's based on evidence, and my understanding is that I joined a team where anyone is investigated, from this government or from the opposition. And, in time, things will be balanced, because it's a transparty organized crime or corruption. Now, who is first or who is second, is based on evidence. Well, anyway, all this government looked at me like an enemy. They said, we have the Minister of Justice in the government and we are investigated. I said, yes, that's life. And then the Prime Minister tried to, I'm telling you the stories just to realize how the history goes. And the Prime Minister didn't give up, and he said, okay, but maybe you find the channel, a way to build a channel between the prosecutors and me, the Prime Minister, and I would know before anyone else who is investigated from the parliament or from high position level in the administration or from the government. And we all know that there are periods of secret surveillance, yes? So I said, no, you will not know. I don't know, and you will not know. And you know what? It's funny to say no to a prime minister or to your boss. They never expect that. They don't know how to behave, because everyone said, yes, prime minister, yes, prime minister, yes. And here I was, and I said, no, you will not have such a channel, or no, I'm not signing this, or no, I don't do this. And I realized that at the beginning, it's a shock. They don't know what to say. And it's in your advantage. So, in a way, now we do very well with the anti-corruption in Romania, because we have this anti-corruption directorate formed of prosecutors, and they are embedded in a body with financial specialists. They do financial circuits for money laundering, all sorts of experts, and also judiciary police. It was very difficult to keep this body alive and not and avoid being dismantled by politicians. But a few of us succeeded. We used the American Embassy, we used the European Union, we used different external factors to keep it going, and the people have trust in this institution. It's about 80% trust. In the political parties, it's 10%. But still, people don't go on the street, to defend the institutions. They don't have this practice to go to demonstrate. But it's there. What I noticed is that I expected a day in which politicians or the judiciary will say, okay, it's time to stop. They catch us. We did it, now we stop. No, this day doesn't come, and I'm sure it will never come. What I notice is that for the last over 10 years, they try to find more sophisticated ways. And I'll give you an example. We had last year a Minister of Finance in office who was taken from the barber shop. And what he was doing, he was buying paintings, and he built in one of his many houses double walls to hide them. Or we had judges who stopped the elevator between two floors, thinking that the interceptions, they thought they could be intercepted, so they thought they could be investigated, thinking that interceptions would not pass through the walls. So they just can't refrain from being corrupt. Or we had another judge who got 21 years in prison, for instance, last year, or this year, 2016, who was calling the clients in his cases in the toilet, I'm sorry, but that's how it happened, in the toilet, flushing the water, hoping that the interception could be, his voice could be covered by this. It's incredible. But all these people are caught. And I'm just telling you how their brain functions, not to stop, but to find different ways to escape. So they are caught, and they are sent to trial. We have a lot of ministers of finance, of all sorts of ministers, former prime ministers, sitting ministers. We have 4 sitting finance ministers arrested and in different stages of the judicial procedure. We had a point last year when no one wanted to be a finance minister. They're all afraid because all were taken all for one after another. Now, we have corruption, but we fight it efficiently. My problem is that the countries in the region, Central Eastern Europe, they have corruption, the same level of corruption, but they don't fight it. They don't have efficient institutions. And now, and I'm finishing right now. I want to say, looking back how we succeeded, one single person can make it. You can't do it with a system. The judiciary system in itself will never change. People don't like the change. They don't like to change their habits, to learn new legislation, to change their network of friends. They don't like change. They like their old, nice, good life. So don't expect the professional category to come and to say, we want to change ourselves. No. You need an agent of change, like an engineer would explain you how a system is broken by small help me. Okay, small holes done by sharp instruments. So these agents of change coming from outside. So it's enough one. Then you find someone in the system, because you find 1 or 2 or 3 people in the system who are good and professional and really independent. And that's enough. And then they will bring other people like them. And the system will build by itself. You just need the first one who should have the power to do it, yes? The political power and the stubbornness and to take the risk, because you have to take the risk to do it, to start it. And then it works by itself. As you say, the ball is rolling. And I'd like to to quote something which I like very much. It was said by more people. One of them was Mark Twain. He said there are two categories of people on this earth. The first category are the people who adapt themselves very easily to the surrounding world. The second category is formed of the people who want to adapt the surrounding world to themselves. Who do you think are the people who bring the progress? Those from the second category, who want to adapt the world to themselves. Like, I have a dream, Martin Luther King, yes? It is enough one person with a dream, and then more and more and more people. So, the same, we have to look for these individuals who want to adapt the world to themselves. And that's the only way to make progress in civil rights, in anti-corruption, in democracy, in anything we want in our life, in our cities, in our countries. Thank you.
Thank you so much. And it's good when there are game changers. But it's even better when these game changers are supported from outside. And that's why I would like to invite our next speaker, Ms. Baltinskaya.
My good luck is to speak about good people, because the gentlemen and ladies were speaking about the corrupted people. I want to tell you about Americans who supported human rights movement in the Soviet Union. It started in the middle of 50s because before Stalin's death, it was impossible to support human rights movement because it was impossible to find any human rights movement. Every civil resistance was suppressed very harsh. So at my first picture, you can see the faces of the persons who, up to me, they were outstanding persons in the supporting of human rights movement in the Soviet Union. Between them, you can see some presidents and, of course, congressmen and senators. Of course, they are not all of them. I think that during my study, I will try to complete the list of those persons. So let me start with the support of American legislators. What did they do? They attracted public attention to the numerous cases of the human rights violation in the USSR. Of course, they used a mechanism of economic and political pressure. It was going far beyond the political confrontation with the Soviet system because, of course, American legislators and America itself had some wish to restrict the Soviet Union. But when we see, for instance, at that picture, it is a small picture, the third picture, we can see Senator Kennedy, who is meeting former refuseniks at the board of the plane which came to Boston from Moscow. And it was not obligatory for him to do it. It was just his wish to do it. And of course, this support of American legislators, it was dictated by the fear of the spread of communist ideas in the USA. I read some investigations, some hearings, Congress hearings in 1934, it was conversation with the leader of American communists. Guys, I'm afraid of him because he was very, he was ready to do every cruel things that Russian communists have already did. What was the origin of idea? I think that I can speak about a National Security Council report, United States Objectives and Programs for National Security. It was the first time when they mentioned that they want to find some groups of people in the Soviet Union and encourage them to initiate some national movements. There were two persons whom I should mention, obviously. First of them is George Kennan. He was a diplomat and historian. His first action was a famous long telegram which was sent from Moscow to America in 1946, in which he was talking about need to resist to the Soviet propaganda. But he speaks that all Soviet propaganda beyond Soviet security sphere is based basically negative and destructive. It should therefore be relatively easy to combat it. The second his big deal was a political warfare in 1948. It was the idea of a public committee working closely with the US government to sponsor various immigrant activities. And in 1949-1950, he started two committees. It was Free Europe Committee and American Committee for Liberation of Nation of Russia from Communism. These two committees, they led to radio broadcasting, using immigrants to inform and propagandize the Soviet listeners and East European people. So we can show the first step. It was the radio. In 1947, Voice of America begins Russian broadcasting. It was not political radio. The goal of it was to show the cultural and eventual life of America to Russian listeners. From the other hand, Soviet Union perceived every foreign broadcasting in Russian as trying to influence to their internal affairs. In 1950, Radio Free Europe goes on the air. It was the radio from the countries of Eastern Europe. And in 1953, Radio Liberation, later Radio Liberty. It's interesting that the first broadcasting day of Radio Liberty was at that very day when Stalin died. And at that very day, it was a Representative Kersten who first told in Congress that we should support Russian civil suppressor. But first, I will tell you about national intelligence estimates, anti-communist resistance potential in the Sino-Soviet bloc. Unbelievably interesting reports, believe me. 1955, 1958, and 1966. What do they do? What did they do? They tried to evaluate ability to resist from inside the Soviet Union, from inside the China, and some other countries. Now let me tell about my favorite gentleman, Mr. Kersten. So he not only told about ability of resistance. In 1951, it was Kersten Amendment, which directed Congress to appropriate about 100 million annually to support resistance behind the Iron Curtain and to support the refugees who could come to other countries. In 1953, it was creation of the Select Committee to investigate the incorporation of Lithuania, Latvia, and Estonia into the USSR. In 1954, this committee replaced by the Select Committee on Communist Aggression. Of course, they investigated not only penetrating of the Soviet Union to the Baltic states, but also to the states of Eastern Europe. And committee's activity, public hearings in the United States and many other countries, testimony of many witnesses and approximately 1,500 of exhibits, investigations. And after the committee completed its study, its findings were presented in 27 reports. I think that the activity of Mr. Kersten and his committee was some kind of sweet child of McCarthyism, because between his Congress activity, he worked with Mr. McCarthy, and it was he who also investigated cases of internal communist problems in the United States of America. Up to me, maybe it could be very cruel, because the real people were imprisoned, but again, I will repeat that America was scared by spread of communism inside the country. Some facts about this committee. The committee was assisted by Department of State, United States Information Agency, Committee for a Free Europe and AMCOM-LIB, the Foreign Operations Administrations, and the Legislative Research Service of the Library of Congress in Georgetown University. First investigation was about the Baltic countries. If you look at the left part of the picture, you can see the back of Congressman Kersten, and then you can see some woman. She doesn't wearing hijab. It's Lithuanian woman who is giving her testimony, and she's afraid but, because her relatives could be suppressed in Lithuania. So there were many hearings, there were many witnesses. I read the book, it was a really outstanding book. At the beginning of the page, you can see the report of New York Times about the Soviet invasion to the Baltic countries in 1940. The second topic of Kirsten Committee was Soviet Jewry, and I think that he just opened the way to the other numerous commissions and committees which supported Soviet Jewry. Because in 1955 it was hearings and investigation, treatment of Jews by the Soviet. There were 2 resolutions. And after Mr. Kirsten, in 1963, many American Jewish organizations, they pushed congressmen and senators to do something to support Soviet Jewry. And if you will look to the list of Jewish immigration from the Soviet Union, you can see that only after America participated in this fighting, this number increased a lot. So in October 1963, just only October, 17 requests to the Secretary of State from different congressmen with the questions about the plight of Soviet Jewry. And every request is accompanied by a lot of requests from the people, from the residents of different congressional districts, and they are asking Mr. Congressman, help us, help them, help them. And I saw also 3 requests from senators to the Secretary of State. They speak about the sale of grain to the USSR. We see economic mechanism, and they ask if it is possible to underline that the part of flour made therefrom would be available from making matzov. It's 1963. Some quotes, I will not repeat them. They are quotes about the plight of Soviet Jewry from President Lyndon Johnson. There was Senator Jacob Javits, who he did a lot and he told a lot about Soviet Jewry. And there was Senator Robert Kennedy. I know that there were several members of Congress who visited the Soviet Union a bit later, and some of them were really expelled from the Soviet Union for their support for Soviet Jewry. Why attention was focused specifically on those groups of people? I mean, Baltic states, Ukrainians, and Soviet Jewry. First, they started to show their potential earlier than the others, because after the Second World War, big groups of resistance were both in Baltic states and Ukraine. After the Israeli state appeared on the map of the world, many Jews, Soviet Jews, they announced that they want to emigrate. So those people, they started their activity earlier than others. They had some contacts with their communities outside of the USSR. It's really so. And their resistance, both armed, if we speak about Baltic states and Ukrainians, and peaceful, if we speak about Jews, it didn't stop despite of suppressing. I think it's important. Now Senate, April 1964, there were 3 persons, Senator Javits, Senator Abraham Rybikov, and Judge Goldberg, who made another investigation about this Soviet Jewry's plight, and there were three important things they said. We must give them, to the Soviet Jews, voice, we must rise to their defense, and we must cry out for justice and justice. Reasons of their activity. Of course, I told about danger of communist influence around and inside of the USA. Of course, it was an attempt to weaken the USSR by all means. And of course, there were supporting forces that could do it inside of USSR. And I think that it was some moral act, because they were really sympathizing for the suppressed categories of citizens. In 1955, as I have already told you, was the first evaluation of dissident potential in the Soviet Union, and it was rather poor. Last of those reports was in 1966, and I make a quotation. Intellectual discontent in the USSR doesn't threaten the overthrow of the regime, nor is it likely to do so. So we see that they were not looking for some fifth column. They were not looking for some persons who will overthrow the regime from inside of the USSR. It was moral supporting. Now I'll tell you about some different forms of support. Financial support for dissemination of information. Voice of America, Radio Liberty. In 1972, it was a big scandal in Congress about Radio Liberty because they were financed by the government of the United States, but secretly. But after it, everything went outside and they continued. Investigations. I know several of them. Baltic countries, Jewry, Soviet Jewry, Ukraine, prison, labor camps in the USSR. It's a very interesting investigation. And punitive psychiatry, abuse of psychiatry in the Soviet Union. I cannot enumerate hearings, records, and resolutions, many of them in Senate and Congress from 1950 to 1990. Visits and meetings in the USSR. Of course, they started from refuseniks, and it was the most famous group of people. Many congressmen, senators, and even just simple tourists came to visit those people. I know that one of the gentlemen spoke about a Helsinki Commission in the Congress. It was the lady who invented this idea. Her name was Millicent Fenwick. She was a very extravagant lady. She came to the Soviet Union, and after it was her idea to create such a commission, and the first chairman of this commission was Dante Fascel. So I know that many American congressmen and senators met with dissidents, and it was Millicent Fenwick who also met the dissidents because she didn't know about their existence. It was some Jewish activist who led her to Yuri Orlov, who was at that time the chairman of Moscow Helsinki Group. Another point of interest is legislative acts restricting economical and other relation with the countries where human rights were being violated. You mentioned Jackson-Vanik Amendment, but it was not the first and not very sensitive for the Soviet Union. The first of them was Foreign Trade Act Amendment. Another thing which I should mention was Stevenson Amendment, which restricting giving loans to the Soviet Union for mineral exploration, and it depended also from the freedom of immigration. Other public laws, we can remember Kirsten Amendment, which also directed some money to support people behind the Iron Curtain. Negotiations between the USSR and American governments about exchanging suppressed people. It was favorite Soviet dissident Yuri Orlov. It was Natan Sharansky, who was exchanged for some other people, and it was Vladimir Bukovsky, who was exchanged not for American citizen, but for some Chilean communist with the participating of the United States. And of course, there were meetings in the USA. There were Bukovsky and Sinyavsky and Grigorenko who met with different presidents. Here you can see some pictures with presidents and dissidents. At the right side, at the upper part of picture, it's lunch, which President Reagan gives for the Soviet dissidents. Lower, you can see President Carter, who meets with Mr. Bukovsky. At the left part, there is not only President Reagan, but there is Senator Moynihan, there is Congressman Thomas Lantos, there is also Senator Kennedy, and they meet stepdaughter of academic Sakharov, academician Sakharov. So the world was pondering, the USA was acting. I tell about first public law, which was telling about President should deny any economic or military assistance to the government of any foreign country which practices the internment or imprisonment of that country's citizens for political purposes. It was before Helsinki Accordings. It was before many other acts. As a result, I can speak about real help for many suppressed people and their families, really. I can speak about monitoring of the situation of the political prisoners in the USSR. And there were two congressmen, at least two congressmen, who visited Perm political camp in 1988. It was chairman of Helsinki Committee, Christopher Smith, and it was former congressman from Virginia, Mr. Frank Wolf. They visited Perm political prison, and they heard that there was some scandal. Some of the prisoners tried to give them some note, and they couldn't take it because there were a lot of guards there. And of course, it was some kind of protection for many people because as far as the world knew about some political prisoners, I have watched many hearings in Congress about the plight of political prisoners, Valentin Moroz or Georgy Vins or Natan Sharansky or some others. So it meant that those people, their guards, they couldn't do everything they wanted with them during their being in prisons. Overall, American support was useful for the Soviet citizens who wanted to emigrate, potentially useful for the Soviet political prisoners. I think that it's my opinion that it was more moral than tangible. It was known by actions that couldn't be explained by only political goals. And it was sort of a matter of honor for many Americans, and my thanks to them for that. We'll talk about can it work today? I think that modern Russia is very different from the former USSR, though there are many cases of violating international laws as well as human rights inside the country. One of the main Soviet problems, freedom to emigrate, is not topical for modern Russia, at least now, because I know that they are making some restricting laws. Political confrontation between the two countries is not so harsh today. The threat of international terrorism is common to Russia and America. Restrictions against the Soviet system, if we will compare Jackson-Vanik Amendment and the list of Kardin, Jackson-Vanik Amendment was against the whole country. List of Kardin, it tries to persecute the concrete persons. It's personified. But of course, both restrictions at that time and at the modern time, they influence the entire country. And I think the idea of pushing another country to respect its own constitution and international rules also, without military aggression, is very relevant today. At the end of my speech, I should say my special thanks to my sources of information. It's, of course, Library of Congress, Library of the Kennan Institute, Woodrow Wilson Center, and I made a documentary about Soviet dissidents, and during that series, I made a lot of interviews, and it's also my source of information. So thank you. Here are my contacts if you need, and thank you very much.
Presentations. Would you like to make any additional comments? No. If not, then let me ask a few questions. For example, in the US, Miranda and following court rulings were able to strike balance between two major goals: promotion of law enforcement and securing civil rights and interests of the individuals. Why it doesn't work in other countries? What can be done to reconcile these diametrically opposing interests in the countries we are talking about?
You ask me?
Okay, anyone. Okay.
I would say it starts from the different criminal system. It's true that as we speak, and for many years ago, the difference between a continental system, which means the law is important and not the jurisprudence, and the common law system, which is specific to US and the UK, which means the judicial precedent is very important. Now, this difference is not divided strictly as it was 10, 20 years ago. Now we have the European Court of Human Rights in Strasbourg, we have the Court of Justice in Luxembourg, the Court of European Union, and they both rely on jurisprudence, totally and fully. So it's a mixture. However, as I said, there are differences between the way we see things. As I said, the main difference starts from the point that in many countries, the arrest of the person is not the moment you deprive him of freedom physically and you say, you know, you have to come with me to the police. That's not the moment when we consider that it's arrest. If he's kept at the police for 2-3 hours, then yes, you can say it's arrest. But that was again taken by winning a case with the European Court of Human Rights. It wasn't in the law. So that's a difference. Otherwise, the informing of the people is, I don't feel comfortable like this. Otherwise, the informing of the people comes when the person is, again, before he's interrogated as a suspect, not even arrested. Maybe you will not arrest him. You just interrogate him and he will be indicted in still being free. So that's the difference. Now, since I have the floor, I'd like to say something else, but not related to your question.
No, everything is perfect. Thank
To
you.
the Russian Federation danger, which I'm very much concerned of today, and we are all in the post-communist countries, and I speak of Poland, of Baltic countries, of Romania. I strongly believe that the Soviet Union leaders of the political establishment in Russian Federation today and yesterday and so on, they never gave up. Like the corrupt politicians, they never said, okay, the Soviet Union is over and that's it. We let these countries go. No, they don't. And as we saw in Crimea and as we see in different other countries, they think in long terms. That's the difference. They think in hundreds of years, and they make plans, long-term plans, and they want all these countries to come under their influence. And because you spoke today, you referred to the role of Radio Free Europe. I can tell you that now, so Radio Free Europe and BBC left these countries, Central Eastern Europe, because we joined the European Union, we are democratic and free and so on, we don't need them. Well, that was a mistake. What happens now is that the Russian Federation replaced the Radio Free Europe and BBC, and they bought, for instance, in Romania, they bought licenses to open a TV. They already have a radio, Russia Today, and a lot of blogs in Romanian. So now they broadcast in Romanian, as Radio Free Europe did and BBC did, for the Romanians to understand what's happening in the big world, yes? The same are doing the Russians. They broadcast in Romanian. They bought in Crimea and then in Ukraine, and then Ukraine gave them and withdraw them. Baltic countries refused to sell them the frequencies and the licenses to broadcast in their language, in their countries. In Republic of Moldova, they broadcast freely and they have the license. I don't know why Romanian audiovisual visual body sold them the license even to open a television, but they did. So my appeal is Radio Free Europe and BBC, please come back and do more than that, more than a radio, also television, because it's a danger. And I can see in the last 5 years, the anti-American, the anti-European Union, the anti-democracy speeches and blogs and, leftish people and groups who switch the mind of the people.
Well, you are at the podium. May I ask you another question?
So I'm staying here.
Keep the platform.
When you conducted your reforms in Romania, you used human rights mechanisms and principles to help to fight corruption, like non-discrimination, transparency, accountability. And thanks to your reforms, the country was admitted to the European Union. The judicial system was rid of political dependency. Now it seems that some countries in the region or leaders of some countries are less interested in fulfilling their human rights obligations, and there is a general opinion that human rights is a byproduct of democracy. What can be done to fight this approach?
To elect other politicians than the ones we have today.
Thank you.
Politicians form the state bodies, yes? They don't like civil rights, and they don't like anti-corruption. I couldn't have done it in my country if another country would have done it before, because they knew what to expect, even if it was pre-accession. Now, anti-corruption is wanted by Slovenians, by Czech, by a lot of people, not politicians. People see what happens in Romania and they want it. But they're politicians, because they see what it happened in Romania and that they go to prison, they will never adopt it. They will never adopt such legislation. So basically, when I did it, they didn't imagine what will happen. They thought, okay, we make another institution, we make some other legislation. So now it's much more difficult to do it after we have these results.
Thank you.
But I want just an example to be, for instance, if you go to Prague, the tourism agencies offer you the tour of corruption, just to realize the dimension of this phenomenon. Or in Slovenia, after they joined the EU, they tried politicians' opposition power 3 times to dismantle the anti-corruption agency. And I can give you more examples. So that's another thing of the honor of the politicians. You know, we join the club, we make promises that will go forward, that the reforms are irreversible, and then we do everything we can to go back.
Anyone would like to add?
Okay. Well, just to follow up on the question, what can be done? A proverbial Russian question that we often ask. Again, in terms of what can be done, and our colleague has mentioned this as well, really the push has to also come from within the country, from within civil society. You can't assume that the institutions themselves will reform. That's the lesson so far of Ukraine, that the institutions and indeed the political leadership have been less than thorough in terms of pursuing reform, yet the the civil society has continued to demand reforms. And that is one of the crucial aspects of keeping the process going. The other really depends on pressure from outside. I mean, again, would Ukraine be reforming if the United States and the EU weren't demanding that certain reforms take place? And that requires that the United States and the EU have the courage of its convictions and to uphold its belief in human rights. That's what came through so prominently in Natella's presentation, that in the 1950s and 60s you had a series of politicians who, not necessarily pursuing political advantage, but believed that they were doing something that was right. And that's something that we have to maintain as well.
Yeah, on that point, I would just also add, you had those behind the Iron Curtain, as it were, also very much poking the consciences of those in the West to get even louder. And I'm not sure I completely understand your question, Peter, but I think some of it has to do with balancing security and liberty, and why some of this has been so difficult in the region. And one thing related to Monica's comments as getting rid of the politicians we have, certainly that mood is quite strong, I think, not just in the United States now, but in Europe. It's a populist mood, and I've often wondered if the way to solve what is really the classical problem of politics, of how do you get the right people to serve, because presumably the people who would be best would never want to drag themselves through the mud and serve, is exploring the idea of a jury duty sort of process for politicians or for certain societal boards or things, where you draft a group of peers and say it's your turn this year to make these laws and review this question. But on the question of sort of security and liberty, I think it was FBI Director Comey who's had a difficult year, said that this was the problem that he found the most challenging in his entire government career, and it's only gotten more challenging. From my perspective as a citizen, I think balance is really the wrong word. I feel like in the human rights field, my assumption is that human rights is the perennial underdog, and that our work will never be done, and therefore it's impossible for us to have too big of a success, to really do too much in this area, and thus, whenever it's tried to, whenever it's people are talking about balancing it, I get worried. And I also think that, it's, when I hear politicians, nothing to me is more annoying than the usual of politicians talking about how their top priority is the safety of the citizens or the American citizens, when I, as a citizen, again, would rather hear them say that their top priority is the liberty and freedom of the society. And I haven't heard a whole lot of that in the past decade or so, and I think it's understandable why. And one last thing on perhaps the confusion between the two systems as we look at Miranda and our jurisprudence and that in Eastern Europe, particularly Russia, is the reality of very strong informal practices in Russia. And so I think we're talking about what, and we don't have this as much here, so whatever we have you can actually read in a book, and that exists in Russia too, but it's only part of what is the reality, and that there are vast informal practices that are sometimes realer than the legal framework. So in addition to legal framework, political will, institutional reform, there's this question of, should you move those informal practices into law? Is that culturally appropriate? How do you look at the two and balance the two?
So there is a lot of work to do. There are one.
Can I add?
Just very brief, please.
Yes, of course. I think that it doesn't work because it's too much of political correctness in the world. When we speak about, for instance, Karzin list, we don't mention that Russian president would also be in that list. I think that if we contact with the people who violate the principles of political correctness and laws, we should not follow them. That's it.
Thanks. Monica, you wanted to say something.
Yes, I said elect other politicians. If a politician is corrupt and steals from the pockets of its citizens, we don't have. They can't be called politicians who love their countries or politicians who love the people. And I give you an example. We had local elections in June this year, and one mayor of a big city was in prison, arrested for corruption, and he was elected 70%. He won 70% again as a mayor of the city. Now we have parliamentary elections in 2 days, and there are tens of people, of candidates who have been convicted or are under investigation. So it's out of my understanding. That's why I'm saying we need new people, and it's time. I think it's time in the history of a country or of the world when those who never thought of getting involved into the politics, they have to do it. It's when you stay aside in times of moral crisis, that's the worst crime in Dante. You go in the narrowest, in the most difficult inferno. And I think that's such of a time when some individuals should leave aside their personal comfort, well-deserved, I don't criticize that, and should get involved into the politics and replace them, because otherwise they keep replacing each other and will never go ahead. Thank you.
Okay, thank you so much for joining us today. Thank you for your presentation. We really appreciate having you here and having this event. Thank you.
This has been a presentation of the Library of Congress. Visit us at loc.gov.